This is Chapter 10, Test Review. Privileges are based on a social policy that in some situations confidentiality is more important than revealing relevant evidence at trial. That's true. The jury is not allowed to infer a defendant is guilty based on the fact that he or she invoked a privilege in order to prevent testimony from being introduced at trial. Both the laws regarding privilege and the hearsay rule must be satisfied in order to have a confidential communication admitted at trial. And again, if the person who has the confidential statement tells a third party the statement, then that could be admitted under the third party. The attorney-client privilege applies to statements made not only in preparation for the case for trial, but anything related to the case. But again, the attorney is not allowed to conceal evidence for the client. The privilege not to testify against a spouse can be used only if the parties are married at the time the spouse is called to the witness stand. But they can cover statements made prior to marriage. Some states, let's see here, skip that one. The physician-patient privilege, it's allowed for anything having to do with the medical, not if they made a statement that had to do with a crime, then it's not privileged. A clergy penitent privilege is unique in that it has no exceptions. That's false. There are exceptions to the clergy penitent privilege. It's limited. Nearly all states give newspaper reporters a statutory right to refuse to testify about a source of information that he or she collected for a story which was not published. That's true. And there are times when a complaint in an arresting officer's personnel records can be admitted, but that's going to be under a court order. If a defendant invokes the privilege against self-incrimination and refuses to testify at trial, the prosecutor should make no comment at all about the defendant's invocation of his or her rights. That's their constitutional right to do that. A defendant waives a privilege by telling someone what was said during a privileged conversation. A confidential attorney-client conversation would remain privileged even though the client was accompanied by their spouse or someone else with privilege. The privilege for confidential communication between husband and wife cannot be invoked if the husband is charged with domestic violence, child abuse against one of their children, or bigamy, or the marriage was fraud. The privilege not to testify against a spouse can be invoked only while the husband and wife are actually married. The physician-patient privilege belongs to the patient. The physician-patient privilege applies if the patient consults the doctor for the purpose of diagnosis, treatment, obtaining a second opinion. The clergy penitent privilege currently applies to confidential communications for the religious guidance in compliance with the denomination doctrines. Historically, there were never exceptions to the clergy penitent privilege, but there are now. The First Amendment freedom of press has been interpreted by the U.S. Supreme Court as establishing a privilege for reporters. Oh no, there is no, this was a trick question. There is no constitutional privilege for the media. The statutory privilege that protects reporters from going to jail for refusing to reveal the source applies to the name of the individual who was interviewed, the information used for background for a story that was published, notes about information the reporter did not include in the published article. When the defense demands to know the identity of a police informant, the judge will review the evidence about the police informant in the judge's chambers, so in private. And that is the end of Chapter 10, Test Review.